The family members and friends are better to testify to the brain injury victim's condition. The injured victim is, in fact, brain injured and may not be able to testify to the full extent of their condition. The family members and friends can testify to the injured victim's work ability, effect on life, symptoms and complaints of the injured victim. The family members and friends can also testify as to how the injured victim's condition also affects them. The family members and friends should be able to tell personal stories and personal accounts about these facts. Loss of consortium claim. If there is a traumatic brain injury and the victim has a spouse, a loss of consortium claim should be asserted. This will allow evidence from the spouse's perspective admitted into evidence, whereas without the loss of consortium claim, that same evidence may not be admitted. What evidence is needed to prove a traumatic brain injury? It can be beneficial to submit the following into evidence: accident report, scene photographs, ambulance, emergency records and interviews, ER records, medical records, prior medical records, educational records, employment records, drug use history, long-term prescription abuse. With brain injuries, all the psychiatric evidence will be considered relevant, such as arrest and conviction records, employment records. Also, before versus after evidence. This must show the difference between before the injury and after the injury. Accident witnesses, collateral witnesses, and corroborative medical records. Proving damages in traumatic brain injury cases. The brain is the repository for the soul. The brain controls the emotions. The injured victim may not be able to experience emotions, joy, and passion. The jury must be shown the science behind a mild traumatic brain injury and that it involves sending signals that will never connect. Currently, modern science and medicine do not have a way to show the misconnections. Therefore, the attorney must be able to convey this to the jury. Also, when litigating a mild traumatic brain injury case, the defendants must concede that physical impact is not necessary and that loss of consciousness and concussion satisfies the diagnosis of a mild traumatic brain injury. Moreover, mild traumatic brain injury will always have negative MRI and CT scans by its very definition. The issue then becomes only residual damage. It is always advisable to only present the injured victim client toward the end of hearing all the witness testimony in the case. Doctors, family members, co-workers, and friends should set the stage before the injured victim's testimony. TBI cases are generally supported through the testimony of friends and family, as many people as possible who knew the victim before and also knew the victim after the injury, and can therefore testify to the specific problems and changes in the victim's life. Generally, less testimony from the injured victim may be more in such cases. Proving damages is different for mild, moderate, and severe traumatic brain injury. In mild TBI cases, it is critical in the opening statement to explain that it is mild because the doctors merely chose to define it as such in order to distinguish it from moderate and severe. But mild traumatic brain injuries can be devastating and catastrophic. The jury must be educated from the beginning why it is called mild. After the opening statement, the condition should not be referred to as mild throughout the rest of the trial. Instead, plaintiff's counsel should refer to the injury only as a traumatic brain injury. Moderate and severe traumatic brain injuries are easier to prove. The key is the future, a lifetime of suffering and damages. Big settlements are not obtained unless there is future harm and damage. For moderate TBIs, the jury must see the films, artist renderings of the films, and walk the jury through the depiction. For severe TBIs, a day in the life video is key to allow the jury to see the impact on the life of the victim. Large awards are given when there is future attendant services and future pain and suffering. California Civil Jury Instructions 3932 for life expectancy provides the basis for the calculation for future damages. Plaintiff's counsel shall also educate the jury on the value of money in society when requesting large awards. Compensation must be provided for the life expectancy of the plaintiff. The injured victim will suffer every day until their life expectancy. Compare the price of an expensive object or a celebrity who makes large annual earnings as an example of the value of money in today's society. Or consider the comparison to a fighter jet going down, and the pilot is presented with the dilemma to eject and save his life or try to save the expensive jet. The life is more valuable than the expensive jet. Society values a person's life more. Although these are extreme examples, the comparison to the client's injury is also an extreme injury because he will suffer for the rest of his life. No human being should have to go through this amount of pain. In these type of traumatic brain injury cases, a juror who is more educated and intelligent may be a good member of the jury panel because they can understand the value of memory and brain function